AHLA is pleased to present this special series highlighting the top 10 health law issues of 2023, where we bring together thought leaders from across the health law field to discuss the major trends and developments of the year. Support for AHLA in this series is provided by PYA, which helps clients find value in the complex challenges related to mergers and acquisitions, clinical integrations, regulatory compliance, business valuations, and fair market value assessments, and tax and assurance. For more information, visit pyapc.com.
Welcome, everyone, to our podcast highlighting fraud and abuse issues to watch. I'm Shannon Sumner, a Principal and Chief Compliance Officer for PYA in our Nashville office, and I lead our regulatory compliance practice. Joining me today is one of the authors of AHLA's Top 10 Issues in Health Law, Chris Savas of Sherrard, Rowe, Voigt & Harbison right here in Nashville. So thank you, Chris, for joining me today. Can you tell the audience a bit more about yourself and your practice?
Sure. Thank you, Shannon. It's a pleasure to be here, and thank you, obviously, to AHLA for letting me contribute to the article and here on the podcast. I lead the Government Compliance and Investigations Group here at Sherrard, Rowe, Voigt & Harbison, where I focus on representing individuals and companies under investigation or responding to subpoenas from federal and state government agencies. Healthcare is my largest focus area, but I also have experience in areas like transportation, education, and general government procurement from when I was an assistant United States attorney here. We also represent clients in white-collar criminal investigations. I do some general litigation and healthcare litigation in areas like antitrust and general business disputes. And finally, I'm a Rule 31 listed mediator here in Tennessee. So I do some work as a mediator and an arbitrator, and I'm listed with AHLA's ADR service.
Awesome. Well, thank you, Chris. Want to get right into the article that you contributed. So in your article, you reference the DOJ's $5.6 billion in total settlements and judgments related to healthcare fraud in 2021. And we all know that due to COVID, government activity shifted a bit due to the lockdowns. However, do you foresee a recalibration of government enforcement activities in this year, in 2023?
I don't foresee, and Lord knows I'm not clairvoyant, but I don't foresee a major shift coming as it relates to healthcare, which is obviously the focus of what we're talking about. Of that, when that 5.6 billion number hit, a lot of people noted that it was a rather large uptick over the couple of years prior. But when you look behind that large kind of eye-catching number a little bit, over $3 billion of that number came from two opioid-related settlements. And much of the rest that DOJ focused on in its annual press release continued trends from before and trends that I discussed a bit in my article, issues like managed care, health IT issues relating to cybersecurity and EHR systems, and of course kickbacks, which still make up a very sizable amount of DOJ's fraud enforcement efforts, particularly in the healthcare arena. I think we may see some additional focus on PPP fraud as those matters kind of wind themselves through the system, particularly any QTAM matters that take some time to investigate. But I think much of that is going to depend on how aggressive the department is in going after those cases. For example, many of those cases, with healthcare companies and individuals working in healthcare and outside of healthcare, many of those PPP cases to date have focused on issues like false tax returns or some other obviously false data submitted to the government. I'm very interested to see how far DOJ is going to go in investigating whether, for example, certain PPP loans were really needed by the recipient. And I think that how aggressive a stance the department takes on that could dictate how much of that, how much we see those efforts grow in the next year or two.
Well, I feel like there's been a lot of activity over the last couple of months. And so there was the recent back in September of 2022, the DOJ memorandum, and the title of it was Further Revisions to Corporate Criminal Enforcement Policies Following Discussions with Corporate Crime Advisory Group. What a title. But that combined with the OIG's revisions of certain language and certain corporate integrity agreements regarding really the role of compliance officers and compliance committees. And I'm really thinking of the Biotronic and the Vision Quest CIAs over the last couple of years. But do you feel that 2023 will see an increase in government enforcement activity, particularly through corporate integrity agreements?
Yeah, and these documents have raised some themes that have kind of, you know, been just under the surface for years, going back to when I was in AUSA, and we talked about them there. Yeah, I don't know about, you know, overall enforcement activity, but I certainly do see an increased focus on the nature of corporate criminal investigations, both inside and outside of the healthcare space. A focus on how DOJ is going to keep both individuals and corporations accountable for what they see as criminal conduct. You know, this discussion goes back in a large degree to the Yates memo back in 2015, which focused a lot on individual liability in criminal matters, as well as in civil fraud enforcement matters. And there have been a number of changes and focus kind of back and forth between the administrations. But I think that these recent documents indicate a signal again toward a focus on more aggression in this space. You know, the Monaco memorandum, to give it a shorter title, and the changes to the CIA language seem focused on effective compliance programs and individual accountability. There's also a lot of discussion about corporate cooperation, which is a topic that is spoken about frequently, but has not always been well defined, and often means something different to prosecutors than it does to defense attorneys. And so, you know, kind of thematically here, I think HHS is clearly contemplating an expanded role for compliance committees through the new language in the CIAs that you reference. I think DOJ is focused on the importance of timeliness in corporate cooperation and criminal investigations. You know, one of the goals of having corporate cooperation is to be able to hold the individuals who perpetrated the alleged fraud responsible, and certainly having as much information as you can as a prosecutor in a timely manner is going to make taking those steps a lot easier. And it's not just about timeliness, but, you know, voluntary disclosure of records. There's a very interesting section in that memo to me that talks about records that could be seen as protected by data privacy laws in foreign countries, and the fact that the department is going to recognize willingness to provide those documents rather than, you know, shield them through those data privacy laws. I think that's a really interesting passage, and it's going to be interesting to see how the department focuses on that particular area. And there's, you know, the memo also focuses on the importance of corporate compliance history in seeking resolutions, which again will be interesting how the government factors in prior alleged compliance issues. And one thing that I liked seeing in there, and that I think most defense attorneys will like seeing, is a focus on transparency and the department being willing to share information about its corporate cooperation policies with the public and with the defense bar. And we'll just have to see how much transparency we actually get.
Yeah, that's a good point. And I know from us working with, certainly with compliance committees and boards, it really comes down to a lot of it relates to risk, right, for the organization. And so in your article, you mentioned about the DOJ's increased focus, and this is certainly a big risk area for many of our clients in the areas of health IT and electronic health records. But what I wanted to know a little bit more about is you mentioned about the concept of substantive electronic health record fraud. So can you talk about that and maybe provide some examples?
Sure. And this is, you know, a kind of a name that I kind of came up with for some stuff I've been writing and presentations I've given for AHLA. It's betrays my lack of creativity, I guess, in coming up with cool names. But basically, you know, we've watched EHR related fraud investigations and settlements kind of evolve over the years. When I was in AUSA, and full disclosure, I participated in a couple of these settlements. We had focus on EHR donation fraud and potential kickbacks related to EHR donations. Then we got more into kind of the kickbacks space with regard to meaningful use payments and that type of thing. And to me, kind of the next place I see this going is where you're focusing on more of the substantive nature of fraud and how the EHR contributes to it. One example, and when I was in AUSA, I worked on a matter that had some of these allegations, but just speaking generically, upcoding, I think, would be a big area. So for example, if you are a home health agency and you have to fill out an OASIS form, if you have an electronic health record system and that system can make suggestions for changes that you could make to your OASIS form for, say, the sake of consistency, are we going to be looking at allegations from whistleblowers or from the government that those changes are leading to upcoding of the OASIS form, leading to higher payments to the home health agency? There were actually some of these allegations in the key TAM that led to the recent Modernizing Medicine settlement out of the District of Vermont. And I was very curious and waiting to see what that resolution was going to be, to see if it touched on any of those issues. And it didn't. It actually went in different directions. But there have been a number of examples historically, somewhat smaller ones, but even going back, a few years, where you have an electronic health record system that allegedly has been part and parcel with the actual, fraudulent claims that have been submitted. And it seems to me like that's a next logical direction for this type of EHR related fraud investigation to go.
Yeah, that's definitely an area that would encourage certainly our compliance professionals to make sure that that's front and center related to their compliance work plans, particularly if they're implementing a new electronic health record, wouldn't you say?
Yeah, it's one of those things that I think everyone needs to be aware of on the front end, right? I mean, not just the medical practice, for example, that's going to be implementing a new system, but obviously if you are an EHR developer, you certainly want to be aware of anything that could be even wrongly interpreted as a compliance related issue. There is nothing wrong with revenue optimization. Revenue optimization is a good thing. But any tool that can be used for revenue optimization purposes, or at least I would think most of them, have the ability to be abused and distorted. And so compliance training on that and monitoring how systems are being employed, I think is critical to avoiding, if not trouble in litigation, certainly expensive investigation costs down the line.
Yeah, absolutely. So I want to shift gears a little bit. So, we understand that historically the DOJ has relied on what's called sub-regulatory guidance in a variety of ways. However, back in 2017 and 2018, the Trump administration issued memorandum kind of limiting the DOJ's reliance on this sub-regulatory guidance. But then that stance flipped again with the Biden administration when he issued an executive order instructing agencies to really remove those policies limiting regulatory action. And we know this was the catalyst to the Garland memo. But do you see this as perhaps foreshadowing future DOJ enforcement actions? For example, many of us were dealing with the provider relief funding, and those terms and conditions were based on ever-changing sub-regulatory guidance. But where do you see that that use of sub-regulatory guidance coming up in this year and in the following years?
It's one of my favorite topics, so thank you for asking about it. I do think that those changes in the Garland memo may foreshadow what we're going to see in some investigations in the False Claims Act front, in particular areas. You mentioned provider relief funding. PPP may be another one, where you have this dynamic situation like the pandemic, where the agencies are just trying to move as quickly as possible. There's a significant amount of sub-regulatory guidance flying around. And in those situations, I do think that you may see a renewed focus on using that type of material in bringing fraud allegations. More broadly, and I'm certainly not, this is not a unanimous viewpoint by any means, but more broadly, my view is that the number of instances where the approach to sub-regulatory guidance is going to make a real difference in say your typical healthcare fraud investigation is somewhat limited. I actually wrote about this for one of those other bar associations a little while ago and kind of called it a tempest in a teapot. Because as you've said, you had a change in the approach to sub-regulatory guidance during the Trump administration with the Sessions and Brand memos. You have a switch back with the Garland memo. But if you look at the overall policies of those two memos, they're not incredibly different. I think one thing that demonstrated this was Section 1-20 of the Justice Manual, which again, full disclosure, I worked on drafting when I was at DOJ. It's why this is one of my favorite topics. If you look at that section, it kind of clarified and expanded on the Brand memo, and a lot of the language in there is not all that different from what you see in the Garland memo. What I find interesting is that after the Garland memo came out, if you went and took a look at the Justice Manual as it's published on DOJ's website, Section 1-20 is gone. Section 1-19, which kind of has an overall sub-regulatory guidance policy, is still there. But Section 1-20, which was meant to put some meat on those bones during the Trump administration, is gone. And so I will be very curious over the next year to see whether the department writes something to replace Section 1-20 and tries to put more meat on the Garland memo, or whether it just kind of lets that float and sticks with the language in the Garland memo and says, this is our policy, and so much of this is case by case that we're just going to leave it at that. So I think that's one interesting development to potentially look for. But again, on your kind of standard, run-of-the-mill healthcare fraud investigation, to the extent that such a thing exists, I think that for the most part, the differences are going to turn out to be less critical than sometimes they're made out to be.
Interesting. So, looking into your crystal ball that you have, what are some likely enforcement priorities in 2023?
Well, my crystal ball is always pretty hazy, but I think that, like I said, I don't think there's going to be a massive amount of change. What's passed is prologue. I think that remains true, particularly when you've got so much of DOJ's fraud enforcement activity, relying on and based on the actions of whistleblowers and the key TAMs that they bring. Opioids, I think, is going to continue to be an area. We've had major settlements in that space. A lot of litigation is still going on, on the opioid front in this country, and I think that's going to continue. I think managed care, you're going to continue to see, risk score litigation and settlements. I don't think that's going anywhere anytime soon. Despite numerous settlements in that area over the last few years, it seems to continue to come up as an area of investigation, and I think that's going to continue. Health IT. We've seen a number of civil and criminal enforcement actions related to cybersecurity in the last couple of years at DOJ. The HR matters that I was just talking about, I think that's going to be a focus area on both the civil and criminal sides. And of course, wrapped into all of that and more is that general kickback theme. Obviously, a significant portion of False Claims Act cases in particular that DOJ handles are kickback cases. I think you're going to see that continue, and it's especially in the areas of health IT and opioids, as I just mentioned. There's going to be always kickback investigations related to those areas.
So speaking of that, I understand from your article that there is a interesting case addressing the scope of anti-kickback actually pending here in the Middle Tennessee District. So can you speak to this?
Well, I find it interesting anyway, and I hope some other people do. And again, just to be open, I represented one of the defendants in this case for a time. I'm not involved in it now, and everything I say will be public information. But there is a case pending down here. It's actually a Medicaid case that is pending in federal court. A number of states have intervened and are proceeding with the litigation. The federal government has not intervened. It's called United States XREL Fulse v. Napper. And in this case, at a motion to dismiss stage, the trial court, the district court ruled that the intervening states, could enforce the federal anti-kickback statute through their respective state false claims acts in relation to Medicaid beneficiaries' incurred medical expenses, so their IME payments. These are non-covered services that Medicaid patients can use whatever of their own money they have to pay for because they're not covered by the Medicaid program. The court ruled that that the states could enforce the AKS in relation to those IME payments for services that, as I said, were not covered by the state Medicaid program. I have not seen a precedent to this. I think it's a really interesting application of the anti-kickback statute, and I think it has potential implications for the breadth of AKS applicability. That case is still in litigation, and to me, it's an important one to watch to see where that goes if it gets to a summary judgment stage and beyond. How broadly the language in the federal AKS is applied to a situation like this could have implications down the line.
So I don't think 2023 will be dull. There will be a lot of areas that we will continue to monitor and hopefully to write more on and more podcasts. And so, Chris, thank you once again for your insight regarding the top health law issues in 2023 and for joining me here today.
Thank you, Shannon. I really enjoyed it, and thank you for doing this as well. And thanks, AHLA.
Absolutely. And thank you for AHLA.